I'm actually not a lawyer. I work for the Legal Resources Center, and we are working on the USA Justice Sector Support Activity, which is actually monitoring the implementation of Ghana's case tracking system. And so let me say that by that particular project that we are working on, that is when this name actually came on board. And so it so happens that I qualified to actually, take that name upon myself and then act on the project.
Yeah, but what rule of law specialists, what do you do? What's your, what are your responsibilities?
All right, so basically my responsibility on the USAID Justice Sector Support Activity is to ensure that everything revolving around human rights and issues of governance, issues of access to justice, and then issues of challenges that citizenry face when they want to access justice, we are able to resolve. The other bit also is about, in terms of monitoring the case tracking system, basically this has to do with issues about justice delivery, and the case tracking system focuses primarily on criminal cases for now. And so as a rule of law specialist, what I equally do is to actually work in tandem with the justice sector institutions in ensuring that the case tracking system from the civil society bit also receives the needed public attention and it functions properly.
Right, I'll return to you shortly, but Sani, so you work with the legal aid as legal aid officer. Legal aid, what's your remit? What do you do there?
Yeah, so the Legal Aid Commission, we are an agency responsible for assisting persons who are in conflict with the law and do not have the necessary means to get lawyers. So that's where we come in. You go to courts and people are unrepresented. The judges would make orders directed as us to come in to assist such persons. Other people also come with applications that we have a relative who has been arrested and is at the police station and we need a lawyer for him. And yeah, so basically we are government lawyers who are there to assist persons who do not have the necessary means for lawyers.
Interesting. So then how come that we have people like you and an institution like that of the legal aid, yet there are so many persons, and we've been watching videos especially produced by the Crime Check Foundation, where you would find persons who have been on remand for many years, not even months, sometimes some of them totally forgotten about, yet you are there. How come?
So the issue is sometimes it's about the attention and priorities of people. Because I say that because every time we hear that government is, buying vehicles, resourcing the police to fight crime, government is resourcing the Attorney General's office to prosecute the people arrested by the police. But when it comes to legal aid, it's more like government is assisting people to arrest persons who are in conflict with the law. They are assisting the Attorney General's people to prosecute such persons, but they don't seem to be too interested in, it's like all their efforts at getting these people, and then they also let you go, and then so it's about priorities. That's what I think. Now we are under-resourced, the Legal Aid Commission. We are in all the regions now. Before, they just had some recruitment, about 15 more lawyers. Prior to that, the northern region, which includes the current Northeast and then Savannah, had only one lawyer at the legal aid office. So you can imagine that one person is supposed to be responsible for all the cases in the Northeast, Savannah and northern region. It's just impossible. So I think that in all we have about 35 lawyers in the whole country, and they've just added 15 more. So unfortunately we cannot be we would have loved that we will be more resourced, we will get more personnel to go around and do all the work that we have to do. But unfortunately, it's just impossible. Currently, I tell people, currently I'm handling about 18 murder cases, only me, 18 murder cases, just one person, and it's just murder. So you can, these are persons who were arrested about 7 years ago. At the time, we had non-bailable offenses. Now they finished with the committal proceedings and trials are about to start. They have no lawyers. So the courts would make orders directed at legal aid to assist such persons. We are everywhere. We are the, unlike Attorney General staff, where they go mainly to the High Courts, Court of Appeal, and then Supreme Court, and unless they are doing committal proceedings. At legal aid, you are the district court doing committal proceedings, you are the circuit court doing trials, you are the high court doing trials, you are the court of appeal, and then you are the Supreme Court. At the end of the day, that is what we are doing, and unfortunately we are just few. But we are so overwhelmed, but we are still doing our bit. Just about, I think sometime last year, at the Mile 7 police station, there was somebody who had been arrested. He was sent to court, remanded for 2 years. He ended up spending 5 years at the in Sawam prison.
Wow.
They brought him out, took him to court. The judge remanded him to police custody. The day they were supposed to bring him back to court, unfortunately, the prosecutor didn't go to court, the investigator didn't take him to court. And the judge got angry and he adjourned the matter since then. And at that point, you cannot do that because he's standing trial for a murder case. So you cannot adjourn the matter to an unknown date. You have to make, and the law is clear that you, in such cases, once the person is in custody, the maximum you can adjourn is 15 days. He adjourned because they didn't bring it. He adjourned the matter since then. They took him back. There was no return date for him. They didn't know what to do with him, and he ended up spending additional 5 years. This was 5 years. So he had been out there arrested and in custody for 10 good years for something. The police at the end of the day, he had, so at some point he started developing mental, some mental issues, and that is where we came in, and he was released without trial. And these are some of the things we do. Unfortunately, you see, we're so overwhelmed that the more you do these cases, you can't, we go do sensitization, the legal aid week, you're telling people constantly what you do, everything, and they keep coming, and then the workload is just getting out of hand.
Wow.
So basically,
wow. I'm shocked. But so hearing from the lawyer here, who has to deal with cases of murder, and I believe a lot more cases that even go beyond murder and so on. But he's also recounting to us the fact that persons have been in remand for so many years, go to court, prosecutor doesn't come, and the judge adjourns. Sometimes also because the judges are overwhelmed by the number of cases that are brought before them. And so then that brings us to the meat of the discussion for tonight, which is, in order to make space for the court of law to deal with those matters that cannot be settled outside of the court, people like you are encouraging persons out there who may have some conflicts over issues that are not necessarily so the situation in respect of the extent to which the courts are overwhelmed with cases. I started this conversation by saying, referring to the saying that says justice delayed is justice denied, and then yet we are told that the wheels of justice grind slowly.
All right, so this issue is really a concern, especially to some of us from the civil society, background. I know likewise to everyone. And so over the period, what we have actually seriously advocated for is that there's a need for us to educate everyone on the Alternative Dispute Resolution Mechanism Act, you know, the act which was passed into law somewhere in 2010, Act 798. After series of engagement with some stakeholders, you realize that not everyone still understands what the act provides. Specifically, when you check section 1 of the act, it really spells out various aspects that you can use ADR, you know, the act to resolve. And these issues are, one, matters about interpretation or enforcement of the Constitution, matters about the environment, or matters that actually hinge on aspects or things that you can't really use the act to, and which need to be discussed or decided upon. Probably you can look at criminal cases like felony and those things. But aside that, almost any other thing like tenancy agreement, tenancy standoffs, challenges and difficulties, I mean, we should be able to use ADR to advocate for. So what we do in our engagements and our awareness creation really is to tell the people, everyone, that look, going to court should be the last resort. To be honest with you, if your matter doesn't fall within what section 1 says, and even when you go to court, judges don't really want people to even appear before them. And the reason being that if the matter can be resolved through ADR, there's no need to go to court. And that is why when you go to court, we have what we call the court-connected ADR, which means when the judge looks at a certain matter and realizes that this matter can even be resolved through an ADR, the judge even appeals to parties. But remember, appeals, so it means that in this case, the parties before them, or the disputing parties, must agree that they want to resort to ADR. Other than that, the judge will just continue with that. But once they agree, then the judge will let them go and then use ADR like mediation or any other method to resolve.
So the judge cannot impose that decision on the parties?
Not at all.
Not in any case, not in any, under any situation?
Not at all, by law. I mean, the ADR Act 798 actually specifically says that it should be by consent.
So what if one agrees, yet the other party does not? Then what becomes of that? It means
that they have to still continue. Per what the Act says, it should be a mutual agreement that we have come before the court. This is our matter. At this particular stage, we want to, first of all, go back and use ADR.
Yeah.
And so once they want to do that, then the judge will okay it for them to, they will get a, you know, a mediator to do that for them. And so once the mediator actually mediates the process, and remember, the mediator only facilitates. The mediator, you know, doesn't really impose anything on the parties.
All right, so let me bring you back into the picture now. So we're talking about ADR, and here Enoch introduced ADR as a term here in this conversation. Yeah. Exactly what is it?
So basically, ADR, alternative dispute resolution, is any other process or means by resolving a conflict rather than sticking to the court system, the traditional court system. So we have various types. We have negotiations, we have mediations, we have arbitration, and these are processes that persons or parties rely on so as to resolve issues out of court. Now, if you look at those processes available to parties, there are several advantages. As you said earlier, you go to court, and then on the cost list, you see a judge, you know, having about 30 cases.
For a day?
A day. You go to Circuit Court 1, about 30 cases. What it means is that about 20 of those cases cannot be done that day. So what you realize is that every day before they start a case, they will actually adjourn about 20 cases. They put them on another day just to deal with some few cases. So the cycle continues. Now, if you look at most of the cases, now as you were saying in respect of the Act, the Court Act is very clear. If you go to sections 72 and 73, they encourage the use of court-connected ADRs, where the judge will look at the nature of the case before him and say that, listen, there is something called ADR, looking at the nature of your case, Are you people minded to go in for that as an option? They give you the advantages of it. They try to speak to you, and you know, if you are minded, they refer you to the place. When you go there and deliberate, and at the end of the day, there's an agreement. They would bring it back to the court for the judge to adopt it as part of the, you know, process. If there are disagreements, then it will come back for it to continue. Talking about the advantages, you see that in a litigation, it's win-lose. That's the mentality.
Right.
Win-lose or winner takes all. So before we even get there, you see me as an enemy. So that acrimonious kind of situation where we go to court and deal with the facts or deal with the case and never get to talk, it's removed. In this situation, two parties would sometimes, in negotiations, it's just about you, you know, reaching out to the other party. Listen, this is our problem that we have. This is what I think. How do you see it? And the person will deliberate on the issues and then arrive at a conclusion. Sometimes in mediation, you reach out to a third party, you invite him to look at the situation and your issue and try to assist you, bring some resolution to it. You would also go for arbitration, you know, where it is binding, but it has to be agreed between the two parties. So all these kind of situations, they kind of reduce the delays in the system where you go to court, where you know when your case is starting. In this particular situation, you have agreed on your terms and conditions. The mediator or the arbitrator or whoever is assisting you is just guiding you to come to agreement in respect of what you yourselves have decided to do. So looking at everything, it is less expensive compared to the traditional court system where you are paying the lawyer, you are paying for filing fees. You go the kind of the constant adjournment where you have to pay your lawyer, legal just in transportation almost every time. And then, you know, you also see that at the end of the day, you still get to accept or appreciate the agreement you have, and you still keep your friendship. Unlike the court where you go, you lose against the other party, and that's, you know, hatred and bitterness is always there. So looking at it as a general, you know, it helps a lot, and it kind of mends relationships even after the deliberations and everything. So I think, you know. So
look, what are the kinds of cases that can be taken through the ADR process? So for example, in this conversation, Sani has talked about the fact that he, as a lawyer, has had to deal with murder cases. Somebody murders another person. As a lay person sitting here, and God forbid, if I have a family member, a friend of mine murdered, there's no way I would want to go into a meeting with the murderer to settle that kind of issue outside of court, no matter what the compensation to me will be. I don't know if you have the answer.
All right, so just like I did indicate, when you look at Section 1, it clearly lays out the aspects that you can use ADR to resolve, you know, such as felony cases like murder, rape, defilement. I mean, those ones, the law doesn't allow you to use ADR.
Okay, so I'll ask you to pause there. Rape and defilement, that the law does not allow for ADR?
Not at all.
Wow. Here, on this seat, and having gone out there, I can tell you that some of the cases that have been settled outside of court have to do with exactly what you have just mentioned. Older men defile younger, small girls, and the families come together and, well, in an attempt to so-called, protect the integrity of the families, they decide to settle it amongst themselves. I'm sure you know about these stories.
Yes, so this is really, it's really bad. personally, we have actually got in touch with, some people. In fact, we've supported a lady, let me call a girl in Western region. So this girl was really molested that way by a father. And so we got to hear of it. And what we did, Legal Resource Center did, was to actually engage. Thankfully, Legal Aid Commission, the lawyer for Western region, we made him stand in as amicus curiae. And the difficulty was that this girl's mother was kind of shielding the even girl from appearing before the judge. So anytime they went to court, they would say that the girl wasn't in the jurisdiction of the region and that she had even traveled. And so what we did was to do an investigation, not knowing that because the mother was actually, dating the stepfather. So it appears that they were trying to shield the matter so that once the girl doesn't appear to serve as a witness, then they would actually withdraw the case also. But what we did was to follow up religiously to ensuring that the lawyer there working for the Legal Aid Commission will actually assist by making sure that the girl appears before the court. And so that was what we did. So this is really something that happens in our various advocacy interventions that we do on the field. We've also had instances in which even in certain police stations, it is still persisting, where defilement cases are reported. And then let me give you a classic case in one. I think this is not new, so I can say Sambara Gushegu area. We did some monitoring there on our case tracking system, and then we realized that the police there were having certain challenges because, you arrest someone within that community or that district, then you have people come there, the opinion leaders will come there, that this person is our own, and so please release him or her so that we will settle the matter out of the justice system or the criminal justice system. These are the challenges that we face. So routinely and consistently we keep on educating the people that it is really wrong. Anybody who does that should actually face the law.
Wow. So and I asked that question on purpose because then we can drum home the point that even though we're talking about ADR, there are exceptions.
Yes.
And some of the very, very pronounced problems in our society, like rape, defilement, cannot be settled outside of court. And so if I know of a family that has a young girl who has been defiled and attempts are even being made by the same family, I could report them.
Yes.
Wow, so that's good education for all of us there. But you were making a point about those cases that should not necessarily be sent to court. You may want to continue from there.
Yeah, so just like felony cases and even second degree felony cases, but basically when you look at the act, cases like assault cases, tenancy standoffs, petty grievances that you have with one of sometimes about someone who has defaulted in paying you. These are cases that you don't necessarily have to worry the court system, because already our courts are very much choked with a lot of cases, like the hardcore criminal cases. These are the cases that ordinarily we should allow the court to do. But cases that are quite minor or that are not that serious, we should really use ADR to resolve. And the reason is that if we really use the ADR mechanism to resolve these cases, believe you me, we are going to have a lot of these cases, and our courts, not congested like the way it so happens. That is why we keep saying that the court system should be the last resort. After you have actually exhausted every necessary mechanisms that the ADR, Act provides, except it is within Act, the Section 1 of Act 798.
Sani, as a lawyer, do you feel threatened by the introduction and the seeming acceptability of ADR, given the fact that you yourself have mentioned that then you would have to engage less lawyers and more of ADR persons who are cheaper? You'll be losing revenue, you'll be losing relevance. Do you feel threatened as lawyers?
So, you see, for me, I'm with the Legal Aid Commission. I'm a government lawyer. The private lawyers, some of them, would say, but at the end of the day, it is about the cases in court, if I have some way, somehow, you would have to make a determination on a particular case that is before the court. Now, lawyers, it's not about what lawyers want. It is about a system in place to ensure that there is no delay in the system. I can tell you on authority that most of the circuit courts now, if you go before it now, today, you won't get any date for trial till after February. It's packed, it's choked. So if something happens, there will not be any other way to deal with that matter. The only thing that can be done is for the court to grant bail to the person. A trial cannot go on till after, because the dates are packed. And that's what we are saying, because at the end of the day, it should be about a situation where two people having a conflict or having a misunderstanding and how they are able to go about it. So if we have a misunderstanding and we go to the court, then we realize that the only date that is even available for us to do anything is from February. You ask yourself, if there's a way that we can get a third party to sit together with us and help us get to that understanding, or to get us to settle the matter, wouldn't it be, so it's about something that is prudent. It's about a system that is ensuring that the delays in the system and then other things that are not supposed to go through the normal court systems are taken out from it. That is why there are exceptions, and they say that these things are things within your control, because it is the two parties who would have to decide on what they want, or the judge trying to guide you as to seeing the need to try and resolve issues. But the exceptions are that felonies are not part. Now, if you look at those cases, there are cases for which, the punishment is harsher. So that is what he said. Rape, defilement, and all. Rape, it's from 5 years to 25 years. Defilement is 7 years to 25 years. These are not things that, murder is life, is death by hanging. Manslaughter is like 3 to life imprisonment. So these are cases for which they say that no, the punishment for it is severe. So that is not part of what we are resolving. What we are resolving are just issues born out of situations that could have otherwise, been dealt with, without going through the court to choke the system. That we should leave the courts for serious offenses, but cases for which you can deal with are brought home and dealt with. So regardless of what lawyers feel about it, it's not about their feelings, it's about the system in place where two people know that when we have a disagreement, when we have a misunderstanding, or when we contract business and there's some dispute, we can easily go and get things sorted out so as to continue. And there's also time wasting. You have to be going adjournment up and down. Let's say you are here, you have a program, the court says come at 10 o'clock, your program is at 10:15. You can't say that, you can't tell the court that, oh, I have a program at 10:15. No, you can't do that. If you don't go, a bench warrant will be issued for your arrest.
That's true.
So at the end of the day, it saves people lots of time.
Okay, one message here. I've received a number of them, but I always choose the very relevant ones. Kwesi Oboa says, good evening, Moomen. Great discussion as usual, and your panelists are very well composed and knowledgeable. Well, that's what we do on this show, right? But thank you. Then the message says, my uncle bought a piece of land from, and you mentioned the part of Accra. I would like to leave that out for now. So he bought a piece of land, and later it turned out that another person had also paid for that same piece of land. My uncle then, wanting not to be in conflict with the other buyer, chose to go to the seller to ask for his money. The seller refused to pay, and my uncle went to court. The issue has stayed in court for well over 7 years. My uncle has passed away. The seller, unfortunately, also passed away just last year. Now, I know about this. What can I do to get my uncle's money in order to take care of his children? This is a delicate issue, but I'm sure these issues are not new. You know about scenarios like this?
Okay, so I think issues of this nature, this particular issue like this, have not really come before the Legal Resources Center. You know, like a similar issue of this nature, but I think issues of this nature, they can trace back to where his uncle left off. If he wants to resolve or he wants to get to the bottom of this. What I'm aware of was one particular case that I was actually following up with my lawyer at the time when I was, you know, in work. And so it was really a similar issue though, where, I mean, disputing parties on a certain piece of land. I mean, the parents of those who started that particular, you know, dispute in the court, they had all passed on, and their children had actually taken the case upon themselves, and the thing was to continue.
In court?
Yes, in court. And the thing was to continue. It was likely that these children also pass on, and their grandchildren will actually also, you know, continue.
Just to come in, there are actually cases in court that have been running from 1975, and they are still in court. So
that's older than any of us sitting here.
So what happens is that the first people, the disputants, they go to court, they hire lawyers, they die off, then they come and substitute, their children come and substitute them. The lawyers die, they get new lawyers, and they've been, you know, litigating since 1970s. Sometimes it's not litigation, it's just family property sharing. It becomes a problem, especially they are from different women. They take different positions. One would say that for this person to live in this house over my dead body, for this person to live in this house over my dead body. Now coming back to the question the person asked. Now you see, I always get the opportunity to inform people that when people want to purchase land, the first thing you do is due diligence. That is one. Most people, they get a plot of land, a parcel of land they want to buy. They think, oh, I like where it is, I want to buy. They go ahead and make payments. No. I always tell people, before you buy a land, whether from the chief, whether from someone who has it and is also trying to sell, go to the Lands Commission. Get a search, get the site plan, take it to Lands Commission. There's a whole lot of, you know, bureaucratic, you know, but it is better for you to go through a process and verify than to pay money to somebody who is not the owner of the land. Now, currently, there's a matter I'm handling in court where we're almost done. So somebody is suing, somebody went and reported somebody to the police station for trespass. Now, for you to be liable for trespass, the land should belong to you. There's evidence that they paid money. There's receipts to the chief. The chiefs gave them for payment for that parcel of land. Unfortunately, a search result comes in and it belongs to snakes. So the chief that sold the land to this person is not the owner of the land.
So this kind of situation,
that is why you have multiple sales of land, fictitious sale of land. That is why when it happens, you can report that person for the person to be taken on criminally. Now the other issue is the delays will come in. So what I advise people, one, if I come to buy land from you, I would ensure that the processes, the receipts, the agreements, everything are genuine. Once I get it, and then you decide to sell to another person, I'll come after you for specific performance. Law of contracts, I can deal with you taking a civil remedy against you, but the whole thing, it's become so common in Accra that, you see, because of our system, things are improving, but the Lands Commission, there were times you would put in an application over a year, it is still in the pipeline. So what will happen is that if I sell land to you, then you pay for it. If you go to Lands Commission to check, it will show that it is in my name because it has started the process to be transferred to your name. Now I can decide to sell to Eric within that same time that I've sold to you. He would also go there and it is still in my name. So I can actually sell to 4 people and it will still be in my name because the process hasn't been triggered to change it to your name. By the time he starts to work on it, then he realizes that it has now come into your name because you were the first to start pushing. Then it now becomes the problem between the two of you, and the one who has money now decide. So we have situations where some lawyers go to court. Their client has a very bad case, but the client is rich. They will file processes upon processes. At a point you would abandon the, because you cannot keep up with the processes in court. So just so that people learn, processes you do or the initial due diligence you do before purchasing the land is very important.
Okay.
Yeah.
Said Wali from Legon says, good evening to you and your panelists. I'm enjoying the discussion thoroughly. But I just have a second thought about some of the issues you are discussing this evening. You are talking as if it is ADR that will bring a panacea to the problems in the courts, to solve the problems of delays and so on in the courts. However, I'm also of the view that to stop the delays in courts and the delays in justice delivery, more justices can be appointed to the various courts to deal with some of these issues. Again, why is it that the Ghana School of Law does not want to admit many more lawyers in order to be able to handle many cases so that we stop the delays in the court system? This is somebody's solution to the problem. We are talking about ADR. He thinks that appoint more justices, get a lot more students into the law school, get a lot more lawyers passing out. Is that a panacea as well?
So I want to look at this issue from the bit of the USAID Justice Sector Support activity.
Right.
So basically, it's an activity that monitors the implementation of Ghana's case tracking system. Somewhere in 2018, the Ghana government launched the first ever electronic criminal justice case tracking system, which actually tracks criminal cases from one justice sector institution to the other. So for instance, if a case is reported to the police, because they are initiators and then IOCO, that case has to be, if it has to travel to the Attorney General for an advice, there's a software mechanism that has been given to selected police stations across 7 regions of Ghana. It is expected that that case, with access to an internet, that case travels to the Attorney General for an advice. And we know that per Article 88 of the Constitution, Attorney General has that particular mandate to actually prosecute cases. And so once, if the Attorney General has to, give its feedback, advice, so that it gets back to the police, they do so. Now, the case tracking system works in such a way that it tries to actually track every criminal case that is actually reported to the sectors that have the CTS in them. If the CTS is working effectively and the officers are trained, so we have 6 justice sector institutions. We have the Ghana Police Service, Legal Aid Commission, Attorney General Department, Ghana Prison Service, Economic and Organized Crime Office, and then, the Judicial Service. So if these cases, criminal in nature, for now, are actually tracked from one sector institution to the other, it is really going to reduce a lot of the delays that we have. The reason being that this is an internet. Whether you like it or not, there is a need for us to harness technology in our justice delivery system. And so to talk about the delays that we face, the activity now looks at how every necessary criminal case that is reported can be tracked. Now, if the thing gets to the Attorney General, and it so happens that the Attorney General is delaying in giving its feedback, the system will actually send a notification that, please, you need to, in effect, that you have to give your feedback to the police, so that they can continue with their prosecution if they have to do so, at the lower court. And so that is one of the things. As for the bit about, we're getting more lawyers, it's really key. The reason being that when you look at the current number of lawyers that we have, I think the last time I checked, according to Danish law report, they were just 3,000, just a little over 3,000. And I look at the population of what, 30 million or so, a little over 30 million. We really need lawyers. There's the need for us to get lawyers for almost every disassembly in Ghana here. And it will help a lot. And so I think I subscribe to the need for us to expand the legal education and have more lawyers.
We have 10 minutes more to go, but let me take your view on the issue of more lawyers, more judges, and problem solved, according to one of our texters.
Yeah, so I have always said that there is nothing wrong with having more than enough of everything. As population increases, there's a need to get more lawyers, more doctors, more teachers, more everybody. And once it's available, or even if it's not available, we must create the enabling environment. I am not one of those who subscribe to, let's limit this, let's limit that. The truth is, no matter what you do, there will be good lawyers, there will be bad lawyers, there will be good nurses, there will be bad nurses, good doctors, bad. So there are, if you look at the Legal Professions Act, there are remedies. That if a lawyer is supposed to do something and he doesn't do it, there are ways you can deal with the matter.
But talking about lawyers, let's again, just before we wrap up, let's again turn our attention to ADR.
Yes.
Who you spoke about mediators very briefly. Who are the mediators? How do we trust them? Who trains them? All these necessary, and even so we box everything together. How do we even start the process of ADR? So I have an issue, but I don't want to go to court.
Yes.
Where do I report to? So let's box all together.
Okay. So for us, if you look at the new Legal Aid Commission Act, we have 3 units. We have the Citizens Advisory Unit, we have the Public Defense Unit, and we have the ADR unit. So at the Legal Aid Commission, on daily basis, sometimes we receive more than 100 applications. People, between landlord, tenant, we have insurance cases, we have between employees, employers, we have marital issues. Somebody just wants another person to talk to him and the wife. And these are the issues that come, and they just want a neutral party to listen to their story. Sometimes recently what has increased at the office that I see is between these Uber drivers and their car owners. They buy these cars for them on I think it's a work and pay basis, and they put in clauses that never favor the driver. That if you fail to get the 400 cedis a week, I reserve the right to take back my car, even if you have paid more than half. So you have all these things, they come to the office and we are able to sit through. Sometimes the driver doesn't know, the owner of the car. He's like, oh, somebody drafted this for me, and I'm just operating, with it, because, and you're able to tell, no, sometimes, regardless of what is on paper, once he has paid you, there's something called specific performance. So in dealing with him this way, he can also, so you sit with them at the end of the day. Sometimes they appreciate the thing. You find a landlord and a tenant, they come, they have issues, and sometimes it's just about, a third party telling them that after listening to both of you, what do you think we can do differently? And sometimes they bring suggestions, and that is what ADR encourages. They don't want you to give them the answer, they want you to push them to try and suggest things that would work for them, that the parties can agree. Normally, that's what we do. So at the Legal Aid Commission, yes, we deal with lots of these cases.
But how does the process begin, Enoch?
So basically, let me tackle from the bit of the court. So the court connected one. So once you appear before the court on a matter, and then the judge realizes that this matter can, let's try ADR, all they do is to really engage the parties to understand the need for them to resort to ADR in doing that. Now, at the court, what I'm aware of is that they have some trained persons who are mediators. And so at the court, so they will actually refer the parties to, mediation. And so a date will be appointed for the parties to appear before the mediator. And basically the mediator's role is really to facilitate. Basically, it's not to even suggest things for the parties. It's only to guide them so that they will understand, appreciate the need for them to decide what they want best for them. And once they come out with a decision, then they would actually go back to the court, and the court will have to actually, adopt the decision and as part of the process. Now, at the Legal Resources Center, and thanks for collaborating with the Legal Aid Commission, we understand the challenges that they face. But some of the cases that come before us, we try to also use, just like Senior mentioned, some of the cases that come before us, the person may want to go to court. But once you sit the person down and listening to his case, you try to explain to him or her that this case can we try ADR? And sometimes once you explained, because going to court has a lot of repercussions. Sometimes you may even lose your family. The friendship that you have, and at the end of the day, because it's a win situation, a win and a lose situation. So it really, kind of minus the beauty of relationship. So what we do is to actually discuss with the parties. Now this case, will you want it, if it is such a case that falls within what the Act provides, do you want to resort to ADR? So that once we do that, and some of them, they really agree, and we're able to resolve the issues without them necessarily going to court. But where it appears that such an issue has to go to court, then definitely we have to do that.
I think we need a part 2 of this discussion. The issues are very deep, and 1 hour hasn't been enough to look at all of that. And many of you also sending in messages. Roski Richard Adams, you say you agree the court must be a last option, and you said this is a very educative program. Thank you very much, Richard, as well, for sending that message. But to all those of you who have been sending me messages on WhatsApp as well, we do acknowledge those messages. Many of you just saying that it is an educative program. Yaya Sumani says, my eyes have been opened through this discussion. Moomen, thank you very much for bringing this to us. But let's also thank Enoch and Sani, as well as what's the program called? Those, the effort to put all this together and to bring this to the fore is led by the USAID.
Yes, so may I humbly acknowledge the support of the USAID. So the activity is USAID Access Sector Support Activity, and it is being implemented by the Legal Resources Center. With its supporters, also Crime Check Foundation, Commonwealth Human Rights Initiative, and also Interregional Bridge Group. So we are monitoring how the CTS, that is the case tracking system, is being implemented in 7 targeted regions in Ghana.
Lawyer Sani Mahmoud Abdul Rashid is a lawyer, of course, and he's with the Legal Aid. Thank you very much, lawyer. We are grateful for your presence. Do assure us that we are going to, by all means, extend another invitation to you. Then we can look at the processes involved in ADR. Of course, Enoch took us through the court-related ADR, but there are so many that are not related to court issues. How does the ordinary Ghanaian, we didn't get time to look into that, and I believe that in the next discussion we can spend a whole hour looking at the processes involved and how people like you, Legal Aid and the Legal Resources Center, can come in to help in that regard, and also the larger scope of the justice sector support activity, what it does overall, and so on and so forth. But we also thank you, Enoch Jengure, rule of law specialist with the Legal Resources Center. We are grateful to you, gentlemen. But we are especially grateful to all of you who contributed to the program via your messages, messages that I didn't have the time to read, of course. I do apologize for that. But please, by all means, do keep them coming in. And like I said, we'll by all means have a part 2 of this discussion. Tomorrow, God willing, we'll be back here with another edition of Moomen Tonight. Have a good night. Bye-bye. When the voices that matter speak, they speak to